answer your questions, and help preserve your family's financial future. Now, here's Gary.
You're live. Welcome to Word on Wealth. Happy Monday, everybody. Hope you had a great weekend. It's good to have you along here on the Word on Wealth today. We are going to be talking about all kinds of things. Today's tax day, and this is where we have my associate at GQ Law, Rich Mathurin, come in at the bottom half of the hour, so that we can ask him questions related to all things to do with taxes. Taxes, tax problem solving, IRS, state of California, all those different things. We're going to be talking about those today. Tomorrow is me. You got me solo talking about estate planning, trust administration, wills, etc. Wednesday, Ken Pecos we're going to continue on our discussion, or actually have a kind of a second discussion on building your real estate portfolio. We had some really good response on that show. So Ken and I are going to continue that on Wednesday on how to put together a real estate portfolio. It's going to be the same time, same station. And so it's 2:00 weekdays, Monday through Friday. And then Thursday, we got Anthony Wright talking about our money, our finances, our investments, how to make money in the market up or down. Friday, we got Finding Joy Friday with Kip Harris this week. So we got a good lineup for you this week. Hopefully you can kind of tune in and out throughout the week. Today, the topic du jour, here's what we want to talk about today. And by the way, if you have questions you want to get in on this discussion, I would love it. 888-344-1170, call and ask your questions. I'm happy to answer them. A couple topics. So one, we're going to start out and talk about estate planning for blended families. And then specifically get into some basics, like what documents you need in your estate plan. The reason for that is because doing this on a daily basis, I can see exactly what's missing in most people's estate plans. So I want you to have that, so you don't have to, sign up for a 15-point review and find out whether your trust is good or not. Of course, that's available, but I want to tell you how to kind of figure that out. Okay, so blended families. With the divorce rate in the Southern California, San Diego region being upwards of 65% for first marriages, over 80% for second marriages, and over 90% for third marriages, it's not uncommon to find blended families. And blended, where typically what I mean, it doesn't mean you're married to your third person. It doesn't matter that. What matters is if you have children with different people. So first spouse, you have a kid. Second spouse, you have 2 kids. Third spouse, you have none. That's a blended family. If one of you have the prior child brings it into the marriage, that's a blended family. So anytime we talk about blended family, it's there's just some different things to consider when you have an estate plan. Mainly, the thing to consider is who has the property. Example. If you had the wife, let's say she brings into the marriage a home for, that she got, that she has her on her own, that's considered her separate property. And then husband doesn't have a home, but he's got retirement accounts and money and things like that. What do you do when wife dies? Okay, that's her property, and wife has her own children. Husband has his own children also. Do you let wife basically give the house to her children so that they can then get their inheritance from their mother? That would seem normal, right? People inherit from their parents. That's kind of a normal thing to have happen. But in this situation, you would have mom passing away and giving her house to her children. What about her spouse? And that's the consideration we want to take. Like, what do you do? Do you give the house to your spouse and then hope and pray that he will give it to your children like you asked him to do on his promise? Or is there some way to make that legally binding? Now, my preference as an attorney is make it so things are legally binding. On a promise, and we all, it's not like somebody breaks their promise intentionally, right? It's not like they were thinking about that at the beginning. But let's say the scenario is, like I said, the wife has the house, the husband has some money, and wife dies. Well, wife wants that house to go to her children because that's just what That's what she wants. And that's what her husband and her have agreed to. Okay. So wife dies, husband's in his 50s. And, do you want now the kids who are going to be maybe in their maybe 30s to have that house when husband is in his 50s or maybe even 60s or maybe even 70s, right? Husband needs a place to stay. So instead of saying, okay, husband, when I die, promise me that you will give this house to my children, because he will promise, assuming he's a good guy. I'm assuming he is because you married him. But will that promise keep? And by that, I mean, what if he's young enough where he remarries? Already remarried once. And will he remarry again? That's a good question. More men remarry than women, granted, statistically, but will he remarry? If he's a 50 or 60-year-old guy, I don't know, probably a high probability that he would remarry. So if he does, now he has a new spouse, and the new spouse is probably going to, right, live in the house that he lives in. Well, that would be the wife's house, his second wife's house. And is husband now going to forget about his second wife and now decide, well, her kids are taken care of, or her kids are mean to me, so I don't need to pay attention to him. So we're just going to give the house to his children or his new wife's children. You see the problem? What you can do instead is make it so that it's legally binding. We do a thing called a QTIP trust. And this is done for a bunch of different things. It's not like there's only one QTIP. QTIP is the Qualified Terminable Interest Property Trust. What that means is you create a subtrust that is created on the first death. In this case, it would be wife's death. So on wife's death, the document that's created, the living trust, has in there language that says, if the wife dies first, then we create a QTIP. And that QTIP trust will hold her house. The house will be titled in the name of her QTIP trust. Okay, so that would mean that husband can live there under different conditions. Now, what we typically do is we say he can live there for as long as he stays there. If he moves out for some period of time, then the house goes to wife's children. If he sells the house, money goes to wife's children. If he cohabitates or gets remarried, then the house goes to wife's children. So these are a lot of the conditions, or some of the conditions that you can put into a QTIP trust. That way, it's not just a promise that, hey, don't worry, I'll take care of it. I'll take care of your children. That usually doesn't work out. You want to have something in writing, something that's verifiable and enforceable. That's a QTIP trust. I have a different idea I want to bring up next. If you want to call me, it's 888-344-1170. You can also go to my website, get info from me, gqlaw.com, right here on the water.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Well with Gary Quackenbush. We are here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com, 855-500-TRUST.
You're saving and investing for the future, and that's good. Have you ever stopped to think, where does my money actually go? This is faith-based investing with Anthony Wright.
Most Christian families don't understand this one thing. The money that you're saving for retirement helps fund the abortion industry as well as other liberal anti-family causes. It's the sad, dirty little secret of American investing world. And here's the good news, though. You probably also didn't know that just a few minutes of your time and we'll screen and clean your investments for you. There's no cost, no obligation. Learn the truth about your own investment mix. Then the choice is yours. Remember, the word says when God's money is in the hands of the righteous, the people rejoice. Well, we also are fiduciary investment advisor representatives. That means that our firm makes a pledge to always act in your best interest. Go to BibleSafeInvesting.com. Download a free copy of my book, Faith-Based Investing, or call me at 931-RETIRED. And please don't forget, listen to Faith-Based Investing this weekend right here on Family Talk.
So, Gary, we've talked a long time about estate administration. So what is that, and why is it important?
Estate administration is the distribution part of estate planning. So when someone passes away and they leave money to beneficiaries, the property has to be administered. So it's like taking it from the decedent to the survivor, That's called the estate administration process. So usually you're going to have a successor trustee that's named in the trust. They'll have no idea what they're doing because they've never done it before. So then they call on GQ Law and we walk them step by step on how to be a successful and good successor trustee. We also do the required notifications. We notify the Department of Health Services and all the legal requirements so that they can have the estate administration done properly. We help successor trustees be successful.
Call or click to request your free consultation. GQLaw.com, 855-500-TRUST, GQLaw.com.
Who will you trust with the biggest financial decision of your lifetime? If you're planning to buy or sell a home in San Diego County, do what I do and work with the true San Diego real estate experts. Ken Pecos and the Pecos Group helped me and my family. They can help you. This is Gary Quackenbush of The Word on Wealth. You hear Ken every week here on The Word on Wealth. He's our expert. He's got integrity, exceptional service, deep knowledge of the San Diego, Coronado, and South Bay regions. These are just some of the reasons that Ken Pecos has completed hundreds of transactions. He manages a powerful team of professionals at the Pecos Group, from single-family attached homes to luxury high-value waterfront properties to apartment buildings. Ken Pecos is ready to help you avoid problems and costly mistakes. Learn more online at kenpecos.com. That's Ken Pecos, Pecus.com. Or call 619-977-8419.
DRE number 010566969, brokered by eXp Realty.
Are you considering a unique
GQ Law. Go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's GQLaw.com. 855-5.
You're live.
Right. Welcome to Word on Wealth. Hey, guys, it's Monday, and we have Rich Mathurin coming up at the bottom of the hour. In the meantime, though, we are talking about estate planning for blended families. So the first question we had was, how do you protect the surviving spouse? So the surviving spouse can actually continue to use the home maybe the husband and wife are living in. And then after both of them have passed away, the house goes to a specific side of the family. In other words, in this situation, we're talking about wife owns the home, she marries husband, and they live in her home. Totally separate property. They don't have any intention, agreement between the two of them. They don't have any intention of making the property, a joint property, community property, and that's okay. But if wife dies first, does the house then immediately go according to her estate plan, which would be to give it to her adult children? And the answer is it would, unless you did something. Okay. And that something is going to be setting up a living trust that has a different types of provisions that deal with real property. And I suggested first you might do a QTIP trust, where it says that the house stays in trust, in the main trust, for the use of the surviving spouse. And that can be done in a couple of ways. You can have separate trusts, which I do a lot, where we have a husband and wife and they have their own separate property. They have a blended family. They may not have any children between the two, just they each have kids. Then we'll do two separate trusts. So husband has a separate trust, wife has a separate trust, and they can keep their property separate. They can use each other's property. They can do anything they want while they're alive. And then once they pass away, there's specific distribution provisions and paragraphs and writings that say what's supposed to happen. So if wife did her own separate property trust, she could have a section in there that says, when I die, my husband gets to stay in the house for as long as he wants, or when he gets remarried or dies or moves out, then it goes to my kids. Okay. And vice versa. But sometimes it's just worth doing the two trusts rather than trying to work a common trust and provision saying, if wife dies first, if husband dies first, then this happens. Sometimes it's just easier, simpler. And that's what we're here to talk about, right? When you come in for your initial consultation and say, hey, Gary, this is the situation. We have a blended family. Here's what we want to have happen with our property. We go through the list and see, basically what you have, what the basic values are. And then we can talk about options that you have available to you. And we make a choice. You guys decide, yes, we want separate trusts, each of us, or we want a joint trust. I've had people say we each want a separate trust and we want a joint trust because they have joint property and they each have separate property and they wanted to keep it separate. It's possible to put it all into one big trust, but it's much simpler if you split it out so that you have a husband trust, a wife trust, and a community joint trust. Not always, but that's one way to do it that seems to work fabulously well. So that's one thing. The other thing with a QTIP trust, like you want husband to be able to stay in wife's house after wife dies, if she dies first, then you could have some type of almost like a rental agreement where the husband he's a tenant of the trust, not that he has the title to the trust while his life. So there's like three ways. You do the QTIP trust. You can do it so that he as basically like a tenant, maybe or may or may not be paying expenses, but as a tenant, that way, if you need to, there's a way to, kick him out if he disobeys or whatever. And then the third way is you actually give him a life estate where literally he has a deed that says it's his until he dies. And then it goes to her trust and gets distributed to her family. So there's a bunch of different ways to do it. And it always warrants a close conversation. It's a little bit sensitive because you're talking about your new marriage and after we're talking about that marriage ending. And I just think the reality is that marriages don't last, right? From a property standpoint, everything, they can't last because beyond the grave, when you die, your property is going to be split up. It doesn't stay together. It doesn't matter, what your beliefs are, whatever, physical property doesn't go with you. And it doesn't, it doesn't stay joint. It has to be split up. So the marriage ends at death. The relationship ends at death, or at least it changes, and the property needs to be divided up at death. So that's why we are talking about maybe a separate trust for each of you, community trust if all of your property is joint. But those are certainly things to consider. So yeah, you may have it so that the surviving spouse is a tenant of the other one. We had a trust. So one we did a while ago is kind of cool, is that we had there was a joint house, and so husband had his separate property, wife had her separate property, and they bought a house together, and basically, it was about half and half. So no matter who died first, we made it so that the survivor would be able to live in the whole house, right? They owned half of it because they were, co-owners, but then they would be able to live in the deceased spouse's half for their life or other conditions. And then at their death or when they moved out, then the property would be sold and distributed to the kids, at least half of it. So what you're trying to make sure you do is that you have some contractual relationship that's managed by a trustee, and that contractual relationship makes it so that your money and property and assets go where you want them to go after your death or incapacity. Okay. The other thing we do is if you did husband and wife each have a trust, we can do something that we refer to as a reciprocating trust, where literally it's just kind of back and forth. When husband dies, money's available for wife. When wife dies, money's available for husband, but then it stays in those separate trusts. We call it reciprocating because it's like back and forth. It doesn't matter which one dies first. It's just that would tell you which trust is going to go into operation. So those are different ways, blended families. And I think talking through the blended family thing is important because California law is not really good with blended families. In fact, it's terrible. Because let's talk about no estate plan at all. All right. Going back to my example, Wife has a house, husband does not. He's got, retirement accounts and some cash. They get married and they don't do anything with their estate plan. They do nothing, no planning. Right? Husband goes in and says, well, I'm going to change my beneficiary designation in my 401k plan. I'm going to say that my money goes to my wife. And if my wife predeceases me, then it's going to go to my children in equal shares. Okay. So his 401k is going to go according to his plan. Now, wife has that house. She has no estate plan, no will, no trust, or nothing. It's her separate property. When she dies, what happens to that house? Well, she's married when she dies. So if she's married when she dies, then half of her separate property is going to go to her husband. Or if she has more than one child, then it will be 1/3 goes to the husband. Interesting, right? So if she's married, half the separate property goes to spouse if she has less than 2 children. So if she has no children, or if she has 1 child, then husband gets half and the other half goes according to the law, which would be it goes to her child. If she has no children, then it's going to go to her family, right? It's going to go to her parents. If her parents are dead, it's going to go to her siblings. So only half the property will go to surviving spouse. If she has 2 or more children, then 2/3 goes to her children and 1/3 goes to her surviving spouse. And those are things like, when you think about it, those are just crazy. You really don't ever want that. One, because it's going to have to go through probate to make it happen, which is going to be a 1.5 to 2 year process. And 2, those numbers it just doesn't work. It's like in the scenario that it's completely wife's separate property and her total intention is to have it go to her children. Why would she want half of it go to her husband? That's not her desire. But understand that with estate planning, all you're doing with those documents is you're stating what you want. You're stating your intention, so we don't have to guess. And we'd never guess, because if you die without an estate plan, quite frankly, from a legal standpoint, we don't care what you wanted. We just look it up in the books and see what's supposed to happen. We don't go in there and go, oh, I'm pretty sure she wanted it all go to her kids. It doesn't matter, because you died without an estate plan. It doesn't matter what you wanted. You never expressed it. Can you do a video will, or can you sit your family down and say, look, this is the way it's going to go? Sure. That's a process that's going to go on for very long if you go through the probate process. But it's like, if you do anything, get a will, get a trust, just do it. Because that way, we don't care what the law says. We don't care how the law would do it by default, because you have just gone and overturned that default and did it the way you wanted to. So blended families, never easy. Get it done professionally. I'm happy to help you with that. If you have your best friend's an attorney or brother or whatever, and they can help you out, that's great. But if you don't have that situation, make me your attorney. 855-500-TRUST. Let us here at GQ Law, let us figure out what to do, consult with you on your different ideas, and let's put something in place so you don't have to guess. You don't have to know the law. You just know exactly what your document says. Okay, sound good. Now, in your estate plan, I want to make sure that you know that it's not just a trust, because I talk about, get a trust. That's one of the things that you get when you do an estate plan. Normally, you're going to have around 12 to 15 different documents that make it so that your estate plan is carried out like you want. The main one, obviously, is your living trust. Okay. Then you have other documents to support that. You'll have a will.
2 minutes.
The will for each husband and wife, and the wills will designate who the guardians are. So wife's will say, I want my brother, and husband's will say, I want my sister, whatever. So the other thing is you do a financial power of attorney for each of you. We do a trust certification, personal property assignments for you guys together, comprehensive transfer. We do deeds, assignment of deeds, assignment of stock, all these different things to make sure that your property is properly stuffed in your trust so that it's under the control of that trust document. Okay, makes sense, right? So will, trust, power of attorney, guardian designation, trust certificate, personal property assignment, comprehensive transfer, deeds to the house, preliminary change of ownership reports need to be prepared and filed so that you can get your, make sure there's no tax implications or there's no reassessment of property tax or anything like that. If you have things like limited liability companies or a corporation, or a sole proprietorship or something like that, then we can actually transfer those by assignment. Okay, pretty cool, right? So there's a lot of stuff you can do with your estate plan. Just if all you have is a trust, really, let's talk. 855-500 trust. Let me look at it with you and make sure that is that really all you need? And I'm going to tell you, if it's just a trust, trusts and wills are different documents, and you need wills to help put your stuff in your trust after you pass away. When you come in for your free review, I will look at your trust. I'll look at your other documents, see if they're good, see if we need to make any changes. We can adapt it to see if you need it to be a retirement protection trust. If you have a blended family, can we amend it? Maybe, maybe not, but let me see what you've got already, and we'll see if what we can do to improve it or to make it so that it does exactly what you want it to. And if you have no estate plan, that's even better. No amendments. We're just going to start over. We're going to do a brand new trust for you, and it's going to be 855-500 trust. We'll talk about it at your free initial consultation. So give us a call and we'll be able to help you out. All right. We got coming up next, we got Rich Mathurin of GQ Law talk about tax coming up next year on the Word on Wealth.
You've got questions. We've got answers. This is the Word on Wealth with Gary Quackenbush of GQ Law. Gary's here to give you peace of mind with expert estate planning, trust administration, inheritance, and probate. Call Gary to build, protect, and transfer your wealth. 855-500-TRUST. GQlaw.com. Call or click to request your free initial consultation or to talk with a member of the team. Call Gary at 855-500-TRUST. GQlaw.com.
You're live.
All right. Welcome back to the Word on Wealth. This is Gary Quackenbush. And it's Tuesday, it's Monday. So we got Rich Mathurin from GQ Law here. He is my associate at GQ Law, and we brought him in, as we do every Monday, to talk about what do we talk about? Can't remember.
Taxes.
Oh yeah, we can talk about taxes.
Death and taxes.
Death. Yeah, I talk about death. Rich talks about taxes. Or today we're going to talk more about death and taxes. I talked about death at the first part, or at least getting ready for it. Let's talk about taxes. All right, Rich. Well, thank you for being part of the show as always. You have had some recent successes recently. I know we always have these little texts that go around in the office like, hey, Rich just was successful with something. But how has the IRS been like with how are things been going with like offers and trying to get things settled? Is the IRS active in getting things resolved, or are they?
I've had really good luck lately with offers. The last one that we had to do an appeal on was about a year ago. Otherwise, they've gone through pretty smoothly. It's sometimes there's a little bit of negotiation at the end, but generally have been very successful in getting offers. Saving the client several $100,000, both in all cases.
So it's like it's like now's the time. We keep hearing, Congress gave, put $80 billion in the budget for the IRS to collect money, and then they took it back away. And people are, I don't know. It's just kind of funny. There's a lot of back and forth. Like, you hear in the news that IRS is getting money to do what? To collect money, right? The IRS puts it in their, it gets put in their budget, and then they get it taken away. But it doesn't seem like, even though the news makes it sound like the IRS is like all of a sudden going to go crazy with all this money and just start banging on people's doors, it still seems like right now it's really a good time to get these things resolved.
Yeah, like I said, I've had really good luck on it. One thing that I do need to emphasize is you do need to be in compliance with the
That's
IRS
right.
for the last 6 years. You have to have at least your last 6 years of tax returns filed. If you're a business owner, you should be filing your quarterly estimated tax returns and make the payments. And one other thing to keep in mind is if you do get an accepted offer, you have to stay in compliance for 5 years going forward. That means you have to file all your tax returns on time and pay the balances when due, or else the IRS can rescind your acceptance and put you back into square one where you're back into collection. So just do keep that in mind. But it is a great program. Like I said, we've saved the clients hundreds of thousands of dollars, a couple of times millions of dollars. So it's a great program, but it does have those little, they do want to, like we mentioned before, they want you both to take care of your old balances, but they want you to stay in. It's more of a get you in compliance going forward also.
Yeah, it's almost like the IRS is saying, look, we'll help you clean up the back stuff by our agreements and all that, but you have got to stay committed going forward. And so the one form that the IRS has that is actually the offer and compromise form is the form 656. And on there, I had somebody ask me, well, what's this deal with I have to stay in compliance with the law for the next 5 years? Understanding, I mean, of course you should be in compliance anyway, but if you were, then you wouldn't be talking to us. But it's like they are actually, my understanding is they're actually signing an agreement where they're saying, I'm submitting this offer and I promise that if it's accepted, I will stay in compliance for the next 5 years, right?
Yes, you are agreeing to that. That's a specific thing that you should, like I said, you should know about beforehand. If you have problems staying in compliance, think about it. But that it is an issue. Like I said, they want to fix the old stuff, but they want you in compliance. They don't want to have to deal with this again. That's basically the thing. They don't want you to create a huge tax balance. It's not like a credit card where you can just keep incurring balances and they'll just put it under the offer or whatever. So the 656 is also, that's about how you will pay for the offer. Usually it's 20% down with the offer. If you meet certain income requirements, they might waive the 20%. If you have income below, believe 43,000 for an individual, they waive the 20% down. And then the remaining balance, the remaining 80% would be paid over 5 monthly installments after the offer acceptance. You can pay, and what's good is you could pay like $1, $4 for $1 each of the 4 months, and then the 5th month pay the remaining 79.99%. So it's a good program. It does give you some flexibility. They're not looking for the offer amount right up front.
Now, you said if somebody qualifies under certain income requirements that they don't have to put the 20% down. They still have to pay 100% of whatever they're agreeing to. It's just that it's going to be paid in 5 months, not 20% down and then 80%. It's going to be 100% has to be paid within 5 years, but they don't have to put the big down payment.
Yes. So with most people, it's the 20% down. One thing to keep in mind is if your offer gets rejected for any reason, the IRS keeps that 20% and applies it to your tax balance. Yeah. So that's another thing to keep in mind. But like we've talked about, Gary, the important thing about doing the offer is make sure that you're a candidate, i.e. you don't have the assets and income where they're going to push you into an installment agreement, and then do it right. disclose all your assets, disclose your income correctly and do it correctly, get your net income number, and, get an offer that the IRS is going to accept. Like I said, I think I'm batting in the 95% range for the offers over the last 3 years. It's been a really successful program for us.
So you're batting at 99. So that, let's see, isn't like a 300 batter. That's really successful, right? Somebody that's batting 300.
Yeah,
so you're
yeah.
battering like 990.
I won a $400 million contract.
Jeez. That'd just be for the first 6 months and your Nike swoosh on your forehead,
Yeah,
right?
But please avoid these guys, these tax firms that are they're going to get you an offer and it's going to pass no matter what. Then they don't even look at your income or assets. We've had a couple of clients that have come in and, I was told I can do an offer and I submitted it. And then the IRS came back and said they wanted $1 million because I have the equity in my home. So, equity in your home, retirement accounts, if you have high income, it's going to be multiplied by 12. So keep those things in mind when you're thinking, if people tell you, the thing that we grew up, if it's too good to be true, it's probably it probably is.
Yeah, it applies to this too. Yeah, and that's the one thing that the one thing is different. So I want to compare this. So like if I'm buying a house and I need to borrow the money from a finance company, right? A lender, I'm going to have to provide the lender with all my information, my up-to-date information, my pay stubs, my checking account, my, everything that they want, because they want to know that I'm qualified. And in fact, a good realtor is going to make you go to your finance guy ahead of time and see if you qualify. And yet we see with this offer and compromise program, because it's so good, that you get people that take advantage of it. And you have these firms that there's no pre-qualification. They are just simply filling out the forms, not even truthful. It's just the client says, I don't know, maybe I make $3,000 a month. And then you can submit the form that's got garbage on it, but you're signing under the penalty of perjury that it's true and correct. And it doesn't matter that you can't say, well, the person that submitted it for me never asked that question, or I didn't know that, I just signed it. You're signing under the penalty of perjury saying that everything in that document is true and correct. So if you submit an offer that's got bad numbers on it or that isn't complete, then when the IRS returns it, then the question is, well, you perjured yourself on that first offer because you didn't tell us that you had 3 cars. You said you only had 2, and you didn't tell us you had a Bank of America account. You said you only had, whatever. So we've seen too many times where somebody really kind of fell into the trap of going to an organization that would just say, we can submit an offer for $150. We'll just offer the IRS $150 and see what happens. The problem is when you do that, you may not qualify, probably
2 minutes.
And when you do that and you don't qualify, then the IRS is going to take a hard look when you try to resubmit. So if you get, and correct me if I'm wrong, Rich, if somebody submits an offer and the IRS rejects it because they failed to disclose a bank statement and a car and their income or their self-employment income, you can't just whip up a new offer and put those numbers back on and submit it because the IRS says, wait a minute, nothing has changed. And you didn't tell us the truth on the first offer. We don't want to take your offer this time.
Yeah, they have a lot of tools. They have all of our access to all of your income, your 1099s, your W-2s. That's where I've come into problems where the client has been truthful with us and has failed to list a job or a retirement account. One failed to list a trust property that he had. Those are the 3 circumstances. Otherwise, if you do it right and you do it properly, and maybe there's, like I talked about, a little bit of negotiation at the end, but I like I said, it's a very, very good program, but you do have to understand that they are going to find it if you don't disclose everything.
Yeah. So it's important to be truthful. It's important to qualify. It's important to go to somebody that knows what they're doing. If you want to talk to Rich about this, the number is 855-500-TRUST. Just call up. You get a free initial consultation. Just say that you heard Rich today on this show and that you wanted to talk to him about the possibility of getting your tax problem solved. And what we're going to do is we've got Rich here to the top of the hour. If you want to call and ask a question, it's 888-344-1170, 888-344-1170. What we want to talk about next is, what if you don't qualify for an offer in compromise? Are there other things that you can do kind of in the interim to maybe kind of have an interim or a kind of a temporary payment plan or something? What are the other options? And we're going to have Rich explain that to us right here on the Word on Wealth.
You don't need to know everything. You just need to know where to find answers you can trust when you need them. Welcome to the Word on Wealth with Gary Quackenbush. We are here to help you build, protect, and transfer everything you've worked hard for with expert estate planning, trust administration, inheritance, and probate. Call Gary and the team at gqlaw.com, 855-500-TRUST.
Gary, you're
Or go online and download Gary's free ebooks and videos. Read Gary's blogs. Call or click to request your free consultation or to talk with a member of the GQ team. That's gqlaw.com, 855-500.
You're live.
All right. You're listening to the Word on Wealth. And today it's Tax Monday. And we've got Rich Mathurin from GQ Law. And we've been talking about offers and compromise, kind of how to be careful. Like if you're going to hire a company to do an offer and compromise for you, get somebody that knows what they're doing and make sure they're being honest with you, like really what's available. Rich has been phenomenally successful with offers and compromise. And I think the number one reason is because he doesn't submit offers that don't qualify. It's not going to be like, well, let's just throw it against the wall and see if it sticks, because IRS doesn't really like that a lot. They, if you do a bad offer, crummy documentation, not supported properly, sure, they can, quote, look at your offer, but then when they reject it or return it, good luck submitting a new one, because the IRS is going to say, hey, you didn't tell us everything last time, and so we don't want to allow you to do an offer. So Rich, I have a question for you. Then if somebody, like, let's say, there's certain things that make it so you cannot do an offer, right? My understanding is you have to have regular income, right?
Yeah, that's our understanding. If you're unemployed or you don't have a regular income source, the IRS will not consider your offer. So I think in those cases, I would probably suggest something that's called the currently not collectible status.
Yeah.
That's where you have to submit financials like you would with an offer, a financial statement, and you sometimes pay stubs and bank statements and the like. But the IRS will put you into what they call it currently not collectible. That's where they're not going to do any involuntary collection activities. That's a garnishment, a levy, anything like that while you're in the currently not collectible. The currently not collectible is just kind of at a point in time. If you suddenly win the Powerball tomorrow, or do get a job or get out, and you get off unemployment, and the IRS gets word of that, they can take you out of non-collectible and put you back into collections. But the currently not collectible is good for unemployed people that may be suffering from a medical situation where they aren't able to work. So, but that's an alternative. But I would not suggest submitting an offer if you have no steady income, because the IRS will not consider it.
So the purpose then of the currently not collectible is that the IRS, and I mean, are we saying the IRS actually has a heart, or is this built into the statute where it's like, if somebody is unemployed, the IRS has been hammering on them, or, the IRS is coming after them because there's a tax liability, that you can get them, the IRS basically, to back off and leave them alone because they're not making enough money, or they're halfway, now they're working part-time and they used to work full-time. They're just not surviving. The IRS will let you put them in this condition called currently not collectible.
Yeah. I believe it is by statute. Again, it's at a point in time, but they do. I think they're reasonable. They understand if you don't have the current ability to pay, they're not gonna, you're not gonna get blood from a turnip, as they say. So, it's a good program. You do have to submit the financials, and you do have to call them and kind of get that they usually have a manager review and stuff like that. So it is a process, but it's a good thing. One good thing about the currently not collectible is the statute of limitation on your balances. We talked about that in past shows. They have 10 years from the date of assessment to collect on an individual your balance. That does continue to run while you're in currently non-collectible. So let's say you're unemployed for a number of years. It's a possibility that while you're in non-collectible, your balances, some or all of your balances might fall off under the statute of limitation.
That's always good news. The statute of limitations, so it continues to run the 10 years during currently not collectible. I like that. So then, Rich, the currently not collectible, I mean, it's currently not collectible, so that could change, like you're saying. If somebody, I guess the conclusion really that I'm drawing is that the currently not collectible that's not a tax, that's not a solution to the problem. That's something that will help. That's one of the things to do to kind of get your tax problem solved. And I just see, a lot of people are touting it as if that's the solution. You can get a CNC, or currently not collectible, and that's a temporary thing. I think people need to understand that. I wanted to ask you though, I know there've been times when you've worked with clients getting, kind of set up for offering compromise where they, you're trying to get their income stabilized. Like maybe they don't qualify for an offer because they just make too much money. And you look at the numbers and say, you know what, you're working overtime like every night of the week. Your 25% of your income is overtime. Sometimes you advise a client to say, look, you need to stop working overtime so much, because if you keep doing that, you're not going to qualify for an offer. Your payment plan is going to be so big, all your overtime is going to go to the IRS. Why don't we just adjust your numbers, back off, work like a normal person, not overtime all the time, and let's adjust it and kind of get into a situation that works.
Yeah, I mean, the IRS or any creditor cannot force you to work overtime. So that's a good solution to lower your income. It would be between you and your employer, obviously, but we do a lot of times for a payment plan to try to get as low a payment plan as possible, or if a client was filing bankruptcy and didn't qualify under the income test, a lot of times cutting back or removing overtime is a good way to allow them to pass for the bankruptcy test too.
So it's not just a one-time thing. Like somebody gets an appointment with you and you say, oh, don't qualify, goodbye, talk to the next person. Sometimes it's really kind of working through the numbers and saying you don't qualify because your income is over this certain level. And I'm not talking about them, obviously we're not talking about, shaving off income or not reporting part of it. That absolutely not. We're talking about like legitimately reporting all of your income, but sometimes, working, a second job, all it's doing is it's making it so it keeps you out of an offer, it keeps you out of a bankruptcy, it keeps you out of a currently not collectible. And then the more you make, the more the IRS is entitled to, because you're just making too much. So sometimes it's like, don't do that second job. Let's work this thing out. Wait till you're off unemployment. Let's work these numbers. And I just see you sometimes doing that with clients. And I think they appreciate that because you're willing to work with them in getting it set up, not just like, okay, you don't qualify, go away, next person.
Yeah, I think I have a couple of situations. I remember one client that he was receiving Social Security, but was working a part-time job at a convenience store, and that convenience store money was giving him a little bit of a surplus income. And the IRS was like, "We want that surplus income."
yeah.
So it's like, what's the point, really?
Exactly.
Get rid of the part-time job, get yourself in, collect the Social Security, survive on that, and allow your balances to run into the statute. And then we can, after we have the balances off under the statute, then maybe we can consider a payment plan and offer things like that. So that's a good way to do it. But extra jobs, if you're showing surplus income, again, when we talk about currently not collectible, you do have to submit financials. And sometimes the IRS may say, hey, you've got, this extra money that we think you should be in a payment plan rather than non-collectible or an offer or whatever. You do have to adjust your income sometimes.
Yeah. And I think some of those are the things that really are helpful for people to know, because you just don't know the standards. I mean, you're behind, you owe taxes, you owe credit card debt. And so you're working extra, you're working overtime, you're trying to pull this off. Sometimes it's just not really possible to get out of it, or it's going to take you so long to dig out of that hole that maybe it's time to meet with a professional like Rich and look at it and say, is there something I can do with my credit card debt? Is there something I can do with my car loan? Is there something I can do with this tax debt, and work out some type of an arrangement? And the cool thing, Rich, is sometimes you'll put in a plan that says, well, if you do this today, it's too soon. If 6 months from now, your situation changes, and you kind of work through these numbers and realize the IRS, if you wait this long, this one is going to fall off. You won't owe it anymore. If you wait, another 2 months or 6 months, sometimes we've had clients wait like over a year, because then they qualify for a newer tax year to fall off, or a newer tax year will be eliminated in a bankruptcy.
Yeah, I think one client he had a substitute for return. That's the returns that the IRS prepares when the client didn't do so. The SFR was going to fall off maybe in, like, I want to say 3 or 4 months. So we got him into a temporary payment plan for that 3 to 4 month period, allowed the balance to fall off under the statute of limitation, the SFR to follow. And then we filed the bankruptcy and discharged the rest of his taxes. And that was a good solution. I think, like we talked about, Gary, the thing that I think we pride ourselves on is there are a number of different tools that we can use, but we got to analyze your situation and kind of give you the best advice based on your circumstances, assets, income, what years you owe for taxes. Do you have any SFRs? All that factors in as to what the best plan for you is.
Yeah. And sometimes the plans sometimes it takes us weeks. That's fast. Sometimes it takes us months. Sometimes it takes us years, because we have these plans. And I know you had mentioned, earlier on, is like businesses, they get treated differently than individuals, and payroll taxes are different than personal income taxes. There's just a lot of different moving parts, a lot of different factors. But it's worth considering. One thing that Rich can do, which is really cool, is a report from the IRS. So talk about that really briefly, about this mass transcript that you can get.
Yeah, let's say a 40-page report that tells all of your years you owe for, whether you filed for, interest and penalties, when your balances might fall off under the statute, when they might be, if they be eligible for a bankruptcy discharge, your payment history, your wage and income history for the last 10 years. Very, very detailed report that I provide an analysis after with, and give you kind of the solutions, that your options going forward. So it's a really good report.
It's the IRS X-ray. Rich will look inside your IRS problem, kind of like the doctor, right? It's more like an MRI. It's not even just like a cheap X-ray. It's like an MRI. All right. If you want that, if you want to talk to Rich about your taxes, please give us a call at 855-500-TRUST, 855-500-TRUST. Rich, again, thank you very much for coming on our Tax Monday, and we'll talk to you in a few minutes.
Great to be here.
All right. Thanks, everybody. Talk to you tomorrow here on the Word on Wealth.
Tell a friend about the Word on Wealth, featured since 1995, with financial solutions attorney Gary Quackenbush, an expert in estate planning. wills and trusts, and tax problem solving. Gary is past president of the California Society of Tax Consultants. Reach out to us. The Word on Wealth team of financial experts is here to answer your questions and help preserve your family's financial future. The information you hear on the Word on Wealth is for general information purposes only. This program discusses general financial and legal topics. Seek legal advice from a competent lawyer for your individual legal needs. The opinions expressed here do not necessarily represent the views of